What is a strategic foreclosure in Florida? Facing the possibility of foreclosure can be an overwhelming experience for homeowners in Florida. With the complexities of the legal system and financial implications involved, it's crucial to understand the options available. One such option gaining attention is strategic foreclosure. In this article, we will delve into the concept of strategic foreclosure in Florida, examining its meaning, implications, and potential benefits for homeowners in distress. Foreclosure attorney David H. Charlip defines strategic foreclosure in Florida. Strategic foreclosure is a deliberate decision by a homeowner to stop making mortgage payments on their property and allow the home to enter the foreclosure process, despite having the financial ability to continue making payments. This is different from a traditional foreclosure, which typically results from a homeowner's inability to make their mortgage payments due to financial hardship. Strategic foreclosure versus traditional foreclosure. The primary distinction between strategic and traditional foreclosure lies in the motivation and circumstances surrounding the decision to let a property enter foreclosure. While a traditional foreclosure is typically the result of financial hardship that makes continued mortgage payments impossible for the homeowner, a strategic foreclosure is a deliberate choice made by a financially capable homeowner. Legal and ethical considerations. The decision to pursue a strategic foreclosure can raise legal and ethical concerns. From a legal standpoint, homeowners should be aware that some states have recourse laws, allowing lenders to seek a deficiency judgment against the homeowner for the remaining mortgage balance after the foreclosure sale. This could result in the homeowner still being responsible for covering a portion of the debt, even after the foreclosure process is complete. Florida foreclosure laws. Florida foreclosure laws are important to understand for any homeowner or potential property buyer in the state. These laws dictate the process by which a lender can repossess a borrower's property if they default on their mortgage loan. This section will provide an overview of both processes, as well as the required notifications and timeline for foreclosure and deficiency judgments in Florida. Judicial foreclosure process. In Florida, judicial foreclosure is the only method of the foreclosure process. This process involves the lender filing a lawsuit with the court to obtain a final judgment of foreclosure. The lender must first file a complaint, which includes information about the borrower, the property, and the loan. Non-judicial foreclosure process. Florida does not typically allow for non-judicial foreclosures, as there is no specific statute authorizing this process. However, in certain cases involving condominiums or homeowner associations, non-judicial foreclosure by a lienholder other than the mortgage lender may be possible. In these cases, the process is generally carried out through a power of sale clause in the lien, subject to certain notice and procedural requirements. Required notifications and timeline. Under Florida law, the lender must comply with several notification requirements during the foreclosure process. The first requirement is the notice of default, which must be sent to the borrower at least 30 days before filing the foreclosure complaint. This notice informs the borrower of their loan default and the lender's intention to foreclose if the default is not cured within the specified timeframe. Deficiency judgments in Florida. After a foreclosure sale, the lender may seek a deficiency judgment against the borrower if the sale price of the property is less than the outstanding balance of the mortgage loan. In Florida, the lender has 1 year from the date of the foreclosure sale to file a motion for a deficiency judgment. Financial consequences of strategic foreclosure. While a strategic foreclosure may seem appealing in some circumstances, it is still important to consider the potential repercussions of intentionally defaulting on your mortgage. Some consequences of a strategic foreclosure can include impact on credit score. A homeowner can explore a strategic foreclosure when their property's current market value is less than the outstanding balance on the loan. Though it is financially advantageous in some cases, it also brings with it a range of adverse financial consequences, particularly on the borrower's credit score. Tax implications. In addition to the impact on credit scores, strategic foreclosures can also carry tax implications for borrowers. As a result of the Mortgage Forgiveness Debt Relief Act of 2007, borrowers can exclude debt forgiven in a foreclosure related to their primary residence from their taxable income. However, this exclusion does not extend to strategic foreclosures involving investment properties or vacation homes. Credit and loan eligibility after foreclosure. The impact of a strategic foreclosure on an individual's credit score can significantly impact their ability to secure new credit and loan opportunities in the future. For example, borrowers who have undergone foreclosure may find it difficult or impossible to obtain a new mortgage loan, depending on the specific underwriting guidelines of the relevant lending institution. Preparing for the foreclosure process. Once you have consulted with a real estate attorney and weighed the risks and benefits, it's time to prepare for the foreclosure process. Some important steps include notice of default. Once you miss a certain number of payments, the lender will take legal action by filing a complaint, initiating the foreclosure process in Florida. Subsequently, you will receive a notice of default, which signifies that you have defaulted on your mortgage agreement, and the foreclosure process has officially commenced. It is crucial to seek the assistance of an attorney at this stage because failing to do so will likely result in losing your home within 6 months. Acceptance and review of summons and complaint. When the lender initiates a lawsuit against you due to defaulting on mortgage payments, they will submit a summons and complaint along with a lien pendens. Lien pendens is a Latin term meaning pending litigation. These documents indicate that the lender has filed a lawsuit against you based on the defaulted mortgage and intends to reclaim your home. After filing these documents with the county courthouse, they become part of the public record. Filing your response. Once you receive the summons and complaint, you have a 20-day window to prepare and file a response. Filing a response is a critical step in the Florida foreclosure process. Failing to file an official response may deprive you of the opportunity to present your case and defenses before a judge, potentially resulting in a final judgment against you and the loss of your home. Attendance at hearings. After filing your response, the courts will schedule a preliminary hearing. During this hearing, you will have the opportunity to present your defenses and present your side of the story. If the judge finds your response compelling and considers it a strong defense, they may request the lender to provide you with additional time to resolve the situation. Foreclosure sale and deficiency judgments. If the judge grants the lender the right to reclaim your home, a foreclosure sale will take place. Typically, this occurs within 30 to 45 days after the final judgment. At the foreclosure auction, the home will be sold, and you will be required to vacate the property. It's important to note that junior lien holders may have the opportunity to purchase the property before the sale, up until the date of the foreclosure sale. In some cases, if you can provide evidence of payment before the foreclosure sale, usually around 10 days prior, you may still have a chance to retain ownership of your home. Call us today at 305-354-9313 to schedule a consultation.